I'm Joshua Kaufman. I'm an attorney, and today we're going to be talking about copyright notices. As we've previously discussed in other segments, you get a copyright by the act of creating the work. You don't have to put a copyright notice on it any longer. Before March 1st, 1989, that was an effective date of the Berne Convention that the United States signed, if you did not have a proper copyright notice on your work, you lost all rights to it and it entered the public domain. Very draconian. There's a lot of people, especially people in the arts, thought it was too commercial and tacky to have a copyright notice, so they didn't put them on. And all those artists lost their rights to their artworks. So there are millions of artworks out there that have entered the public domain because the artist before 1989 did not put on a copyright notice. Since March 1st, 1989, a copyright notice is voluntary. We highly recommend that you put it on for two reasons. One is there's a legal presumption that if you have a copyright notice and you're suing somebody, they cannot claim to be an innocent infringer, and that has a lot to do with damages in a copyright infringement suit. The other is practical. You want people to know that this work is protected and who they have to contact in order to get a license or rights to reproduce it. There's a whole dispute going on right now on things called orphaned works. These are works where people don't know who the author is. People say, well, we want to use these works, but we can't find out who owns it, and the public is being harmed by this, and so on. If you have a copyright notice on it, that really mitigates against that. Now, the copyright notice has three elements. I'm going to hold this up. The first is either a copyright symbol, which we all know, the C in a circle, or the word copyright. The next thing is the name of the copyright owner. Now, it could also be something you're known by. So International Business Machines could put IBM on there. Even though, let's say, you have General Electric, you could put GE. So when they're very well-known initials or other ways of identifying, you can do that. And then the year of publication, the year the work was first offered to the public. So we have a sample copyright notice with my name for something that I would have created this year. So again, they're very important, even though they're no longer mandatory. But if something was published without one of these notices before March 1st, 1978, the creator of that movie, music, artwork, literary work lost their copyrights in there. Thank you very much.